Previous judgment relevant to bar a second suit or a trial under Section 14. Section 40 of the Evidence Act 1872 speaks about previous judgment relevant to bar a second suit or a trial. Section 40 permit evidence of the previous judgment or a decree, which by law prevents any court from taking cognizance of a suit or holding a trial, when the question arises whether such court ought to take cognizance of such suit or hold such trial. The object of Section 40 is to avoid multiplicity of suits and to save the precious time of the court. This provision is incorporated under Section 11 of the Code of Civil Procedure 1908, which deals with the doctrine of res judicata. Under Section 41, relevancy of certain judgments in a probate, etc. jurisdiction. Section 41 of the Indian Evidence Act 1872 speaks about relevancy of a certain judgment in probate jurisdiction. Section 41 deals with the judgments in rem, which binds not only the parties and their representatives but the whole world. Judgment in rem under Section 41 shall be conclusive in a civil as well as criminal proceedings. Under this section, a final judgment, order or a decree of competent court in the exercise of probate, matrimonial, admiralty or insolvency jurisdiction, which confers upon or takes away from any person any legal character, or which declares any person to be entitled to any such character, or which declares any person to be entitled to any such character, or to be entitled to any specific things absolutely, not against some specific person, is relevant when existence of any such legal character or a title to any such thing is relevant. A judgment in rem under this section shall be conclusive in civil as well as criminal proceedings. Under Section 42, relevancy and effect of judgments other than in Section 41. Section 42 of the Indian Evidence Act 1872 speaks about relevancy and effect of a judgment, order or a decree other than those mentioned in Section 41. According to this Section 42, judgments, order or decree other than those mentioned in Section 41 are relevant if they relate to the matter of public nature, relevant to the inquiry, but such judgment, orders or decrees are not conclusive proof of that which they state. Judgment, etc., other than in Section 40 to 42 when relevant, that is laid down in Section 43. Section 43 of the Evidence Act 1872 speaks about judgment other than those mentioned in Section 40 to 42 when relevant. Section 43 provides that evidence can be given of a judgment when the existence of a judgment is itself a fact in issue, or is a fact otherwise relevant to the case. Thus, if a person is murdered in a consequences of a judgment, the judgment being a cause or a motive of the murder will be a relevant fact. The illustration appended to Section 43 show that existence of a judgment may become relevant under any of the provisions relating to relevancy under section 6 to 55. For example, A prosecutes B for stealing a cow from him. B is convicted. A afterward sues C for the cow which B had sold to him before his conviction. As between A and C, the judgment against B is irrelevant. Under section 44, fraud or collusion in obtaining a judgment or lack of competency of a court. Any party to a suit or other proceedings may show that any judgment, order or a decree which is relevant under section 40, 41, 42, which has been proved by the adverse party, was delivered by a court not competent to deliver it, or was obtained by fraud or collusion. Section 44 gives an opportunity to the adverse party to raise question that the judgment obtained under section 40, 41 and 42 by the first party in the previous suit or proceeding on the ground mentioned in section 44. Section 44 is not applicable to section 43. For example, though the genuineness of the will cannot be challenged once the probate is issued under section 41, but the judgment can be challenged that it was obtained by fraud or collusion. The competency on the part of the court means lack of jurisdiction. Thus, if any court without jurisdiction gives judgment on any matter, it is null and void. It cannot be used as the evidence is relevant. Now coming to section 45 to 50, statement by third persons when relevant, expert's opinion and the circumstances when it becomes relevant. The general principle of a law of evidence is that every witness of a fact, not of an opinion, it means that every person who appears before the court has to tell the court only the fact of which he has the first hand knowledge and not his opinion. He has to tell what he has seen or heard or perceived about a fact, not his belief, which are irrelevant. The forming opinion is a judicial function and not a witness. Exceptions. Section 45 to 50 lays down the exception as to when the opinion of the third persons become relevant. Section 45 gives about expert's opinion. This section provides that when the court has to form an opinion in a point of foreign law or of a science or art, or as to identity of handwriting or a finger impression, the opinion upon that the point of person specifically skilled in such foreign law, science or art are relevant fact, such persons are called experts. Under section 45A, opinion of examiner of electronic evidence, this section provides that opinion of examiner is relevant when the court has to form an opinion on the matter or information transmitted or stored in any computer resources or a digital form. It deals with the facts bearing upon opinion of experts. This section provides that the facts are relevant if they support or are inconsistent with the opinion of expert when such opinions are relevant.